This specific case I'm going to talk about is quite different from all the previous ones, as it's not about systemic management of nuclear waste, but a very specific case in Hungary, one single shipment of waste from Hungary to Russia. But I believe that this specific case raises a lot of questions, and my presentation will have two parts. First, I try to summarize in a way the most important developments during the case, and then I will conclude and I will try to find some more general lessons to learn from this specific case. The story itself started quite a long time ago. In 2003, there was an INES-3 incident in the Paks nuclear power plant in Hungary, in Block 2, in the cooling pond of the Block 2, and the spent fuel was left in the cooling pond after the damages. For a couple of years, the block was out of energy generation because of the incident. Finally, in 2006, Block 2 was put back to the grid again. In 2008, the Nuclear Authority of Hungary declared that the deadline for the removal of the damaged spent fuel from the pond in Block 2 is the 15th of December 2015. Still, it is not clear, but I think that this is something to keep in mind, that in 2015 it was the date when the lifetime extension of Block 2, which has arrived to the end of its originally planned lifetime by the 15th of December 2015, exactly the date which was the deadline for the cleaning up of the mess from Block 2. That was the deadline also for the lifetime extension permit. And although we asked the Nuclear Authority if there are any links between the obligation for the cleaning up and to remove the spent fuel, the damaged spent fuel from the block, is linked to the lifetime extension, they officially stated there is no any kind of relationship or link between the two issues. I believe that it's quite difficult to believe or to imagine that you can give a lifetime extension to a nuclear block where you still have a huge amount of damaged fuel rods, spent fuel in the cooling pond. In 2009, the Hungarian Paks nuclear power plant limited contracted, and the Hungarian government contracted for the shipment to Russia, to the Mayak facility, and this was finally countersigned by the Euratom Supply Agency in April 2010. Quite surprisingly, and this was not communicated publicly, in 2013 there was some amendments to the original contract. This is important because there were very different explanations from the Hungarian government for quite a long period of time why the Nuclear Waste Directive is not applicable for this shipment. One of the explanations was that the original contract was signed before the Nuclear Waste Directive, and that's why the new directive is not applicable, which from a legal point of view is just ridiculous, but the official Hungarian ministry and tried to explain that directive which steps into force in 2011 is not applicable for a contract signed in 2009. But even if this would be the case, which is not, or if this was the case, the 2013 amendment of the contract clearly falls under the Nuclear Waste Directive. Because of that, the European Commission should be informed, and they should have examine or investigate the contract from the perspective of the Nuclear Waste Directive. which not really happened. In February 2014, Mr. Oettinger, who at that time was Commissioner for Energy, replied to NTW that the Hungarian government did not notify the amendments of the original contract for the transport of the damaged spent fuel. In 12 of June 2014, the damaged fuel rods were still in the NPP of Paks. I held a press conference to talk about the problem that we'd still have the damaged fuel rods in the NPP, which should be shipped to Russia via Ukraine, at that time in a quite intensive war. And this raises security and safety issues. And also the problem is there that according to the Nuclear Waste Directive, no final disposal of nuclear waste is allowed in a third country unless there are some very specific circumstances which clearly are not there in Russia. So the Mayak facility is clearly not in line with all the European regulation for a final disposal facility. One day after my press conference, the Hungarian government suddenly realized that, we are doing something which we should inform about the European Union, the European Commission. And the day after my press conference, the responsible minister turned to the European Commission and informed the European Commission about the planned shipment in the summer of 2014. On the 18th of July, the Nuclear Authority stated that the planned shipment has been duly notified to relevant authorities after my intervention in the public. But a couple of days later, Mr. Oettinger informed me that the amendment of the original contract was still not notified by the Hungarian party. So there was some kind of unclarity on how far the whole issue was notified by the EU, or the Commission was well informed or not. Finally, in the beginning of July 2014, the shipment has happened. This is the most possible, the red line is the most possible way of the shipments through Ukraine based on the contract between Hungary, Ukraine and Russia on the shipment. Of course, the exact route was not public, but information from the contract suggested us that this is the most probable way or route of the shipment. And in red, you can see the territory where the conflict, the war was most active at that time in the Ukraine, with yellow, where there were some unpeaceful events and there were not clearly fights or war at the territory, but we raised the issue that perhaps in those territories or those regions within the Ukraine, the capacity of the Ukrainian state to ensure the complete security and safety of the shipment was not possible. And this shows that the route went through in a territory where some questions could be raised about the safety and security environment of the shipment. What happened after the shipment? In 14th of August, the Paks company informed the public about the successful transport of the damaged spent fuel to Russia. Not too much later, 1 month, 1.5 months later, however, an aerial transport of fresh fuel from Russia to Hungary happened for the first time. And when I asked the authority why this is needed, as the normal way of the shipment of the fresh fuel is by train through Ukraine, they told me that because of security reasons, because there might be some safety and security concerns which force them to examine the possibility of aerial transport of the fresh fuel. So at the same time, why they believe that the transport of the fresh fuel is not completely safe via Ukraine, still they push through a complete train of nuclear waste the same country, the same way. Then at the end of 2014, the lifetime extension of Block 2 was guaranteed after the cleaning and removal of the damaged fuel rods from Block 2. In April 2015, the Euratom Supply Agency informed me that once the transport has taken place, it's not anymore the supplies agency's responsibility to deal with the question, but this is the European Commission, DG Energy, that should assess the legal status and the consequences, and the agency's signature when required is a necessary condition, including the amendment, and that was clear that the amendment should have been notified for the validity of the contract. And finally, in February 2016, I submitted a complaint to DG Energy saying that the shipment was against European law and they should investigate the case. Just some more general lessons from this specific case. The first is the question of nuclear security, because as I ran my rounds between Euratom Supply Agency, European Commission, International Atomic Energy Agency, NATO, and so on, it became clear that there is no any international body or EU institution which feels itself responsible for ensuring nuclear security. So when I raised the question that who should tell or should have told to the Hungarian government that sending through nuclear waste in a country in war is not the most responsible way of managing nuclear waste, that everybody and all the EU institutions just rejected the responsibility, that this is not their job to do. Finally, what we learned, that there is nobody in the system who should have done that. No action from EC, no action from IAEA, no action from NATO, no action from nobody. The second issue is about nuclear safety and trust. And just let's keep in mind that this is a country which is in negotiations with the European Commission on constructing new nuclear power plants, which is violating the basic European nuclear law in an intentional way. And they clearly knew that there should have been information provided to the European Commission, but they didn't do that till I was speaking about the issue publicly. Then suddenly they informed the day after the European Commission. Then the European Commission initiated or started an investigation on the case. And as far as we know, and there are still no conclusion for the case, they found that the shipment to Russia breached the EU law because, according to the Nuclear Waste Directive, no final disposal of nuclear waste in Mayak in Russia is allowed to the European law. So this final disposal is not possible under EU law. But there is another question for me, and there is no clear statement from the Commission in spite of my questions, that if we are not talking about final disposal, but reprocessing and temporary or interim storage, do we believe that the Mayak facility is a proper place for nuclear waste generated in the European Union to be there, to be reprocessed and temporarily stored there or not, keeping in mind that Germany, not so far or long ago, decided not to ship waste to Mayak from former GDR facilities because it is not considered safe. So this tells me that some of the European member states believe that Mayak is a safe facility for reprocessing and temporary storage. Some other member states believe that it is not. And I think that this raises the question of the coherence of the European approach of this nuclear facility. Finally, the next steps expected. DG Energy, I believe, is not far from closing the pilot they announced regarding the case. Again, we have to take into consideration that there are a lot of issues regarding nuclear capacities or nuclear projects in Hungary, between Hungary and the European Commission. And as far as I see, the Commission wants first to close the investigations and the infringements regarding the new nuclear blocks at Paks, and then once it happened, they deal with the further questions. So I believe that soon after the Paks 2 project is approved by the Commission, we can expect a decision by the Commission on this issue as well. And this is not official communication from the Commission. It's my evaluation of the situation, that the most probable outcome of this pilot is to say that there was a breach of EU law because there is no possibility for final disposal. So the contract should be amended or modified in a way that it's not for final disposal but only for reprocessing and temporary storage in Russia. But at the end, and what is this end? This might mean 5 years, 10 years, 20 years. The damaged fuel rods and the waste should be shipped back to Hungary for final disposal. But I think that the case raises a lot of systemic questions and implications. Also, just to mention that how in a very flexible way the Hungarian government understood European law. If the nuclear waste directive is applicable for contracts signed before, if the damaged fuel rods are nuclear waste at all, because for a long time they stated that this is not nuclear waste, these are damaged fuel, which is completely different, and the waste is just generated in Russia when they start the reprocessing procedure. So there was a lot of very creative understanding of European law, which I believe we can expect from other member states as well. So here I think that the Commission should make steps to make absolutely crystal clear how to understand the nuclear waste directive, and also to give answers to other questions regarding nuclear safety and nuclear security as well. Thank you.
Thank you, Benedek.